Good morning, sir. Are you Jermaine Alexander? And this is 26 DCCR 0178. Mr. Alexander is charged with injury to a child, elderly, or disabled individual. And what is the announcement?
Your Honor, we're going to ask for some more time. I'm still waiting for some discovery. I have not gotten any of the videos yet. Did talk to Mr. Smith about that. We're thinking they might be online, but they weren't given to me yet. So I'm going to double check.
Okay. So if y'all will both check on that. And so, Mr. Alexander, I'm going to reset your case so that Mr. Leish can get all of the videos and everything that the state has. And she'll be able to be out there hopefully before that next court date to go over all of that with you, show you everything. And then we can get an announcement at the next court date. Okay? You go back with the bailiff.
Thank you.
Thank you, ma'am. I could just put a notation. So are you Brian McWade?
Yes, ma'am.
And this is cause number 26 DCCR 0402. Mr. McWade is charged with aggravated assault with a deadly weapon. Mr. Macon has filed a motion asking that I set a reasonable bond. What is the bond currently?
$500,000. It was time.
Were we here already on a bond?
That was the first motion I filed to try and lower the bond, and we denied it.
This is April.
Right. I
April
usually
22nd.
I usually don't do this twice.
Oh, okay.
Unless something, significant has changed, if there's some new evidence. Other than that, it's just a matter of if the case is going to go to trial, then there can be a rejection and we can get it set as quickly as possible. But unless there's new evidence with regard to a bond, I'm not going to hear the same evidence again. The fact that he's still in custody isn't necessarily new evidence.
He has a job waiting for him with Utah, right? As an electrician.
Okay. Ms. Malfino,
Judge,
does the state have?
I apologize. This was formerly a 5A case, and I don't know if maybe it got piggybacked along rather quickly and it was not on our docket. But you could give me a few minutes, I'll either go get it. I would appreciate the opportunity to at least review it. Its court has already heard this. I'm sure my position will be the same as Mr. Coleman's originally was.
Yeah, and it shows on my docket that it's Mr. Nichols. Is that not correct?
It may be, Judge. I think it was an add-on. I didn't have it on my docket, didn't have it pulled for this morning, but we'll get it good.
Okay, well, it's on the regular docket, so it wasn't added on too late, but maybe it was a week or so. Let me hold it for a minute. Just go back with the bailiff.
Some of that is the numbers.
Mr. Hill, in clause number 22-40932, I have an amended motion to revoke your unadjudicated probation. Shows that you were placed on probation March 28th of 2023 for the third-degree felony offense of forgery of a financial instrument. Is it a third? The docket for some reason has state jail beside it.
It looks like it's a third, Your Honor, on the motion, on the admin.
Okay. I just want to make sure I'm saying the right thing because it has SJ on that docket.
It was enhanced, Your Honor.
Okay, so it was a state jail felony forgery that was enhanced to a third degree.
Yes, Your Honor.
And it was a 5-year deferred probation. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you committed the offense of theft of property less between $100 and $750, April 15th of 2026. Is that true or not true? True or not true?
Judge, we can drop count 2. It's duplicative. It's injurious habits. We're committing theft. I'm sorry. We're going to drop count 2 just because it's duplicative.
Count 3 alleges that you're behind in your court assessed fees as of April 16th of 2026 in the amount of $10,859. Is that true or not true?
True.
Count 4 alleges that you failed to report as directed to the probation department for the months of April and May of 2026. And is that true or not true?
True.
Count 5 alleges that you failed to remain in Jefferson County, Texas, and that you were in Orange County June 1st of 2026, where, without permission. Is that true or not true? And then count 6 alleges that you failed to immediately report the arrest for theft of property, to your probation officer. And is that true or not true?
True.
Did you enter your pleas of true to counts 1, 3, 4, 5, and 6 freely and voluntarily?
Yes,
And did you plead true to those counts because they're actually true?
yes.
Give me just a second. I need to look back at some things to understand. Looking for the PSI. Also.
Is your question about the 3-hour?
It's actually a 3rd degree. It wasn't enhanced. It was not
Okay.
enhanced. It was a 3rd degree forgery. That was amended, back when he entered that plea in March to show that it was just the, caption that was incorrect. Okay. Got it.
I'm sure.
What is the status of the new theft case?
It's pending, Judge. When this is over, we're gonna take him down the hall and give him plea to that one as well.
I know.
I believe it's set this morning also.
I realize most of this history is very old. I just don't know that I love a 45-day sanction for someone with this kind of history for the same type of, I mean, it's a theft.
And Judge, if I can, the thing that he was stealing food, it's not like he was out stealing stuff to go, alcohol or anything like that. He and his son started a trucking company. He is going to be gainfully employed when he's released. And he, I think, as far as I know, the court's not really concerned about the money, but he did have an accident which made it hard for him to stay up to date on probation fees. And he's trying to turn his life around, Judge. I think he's, like I said, he started the trucking company. That's a step in the right direction, I think.
All right, so Mr. Hill, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement is for me to continue you on probation, but order a 45-day sanction as, a condition, and with the, I guess, the caveat that you're going to go take care of the other case. There's going to actually be a plea. It's not getting dismissed, correct?
That's correct, Your Honor.
Is that your understanding?
Yes, ma'am.
Obviously you can tell I don't love this agreement. I want to make sure you understand if I follow this agreement and you're in trouble and you're in here again on another motion, it's not going to go this way.
This
Okay.
hearing shows how a judge can balance accountability with a second chance. Mr. Hill admitted to several probation violations, including a new theft allegation, unpaid court costs, failure to report, leaving the county without permission, and failing to report an arrest. The judge openly acknowledged that she did not like the proposed agreement and questioned whether a 45-day sanction was appropriate given his history. However, instead of revoking his probation, she chose to continue it and impose the 45-day sanction, giving him an opportunity to move forward. But the judge's warning was unmistakable. If he returns to court on another violation, he should not expect the same outcome. This was not simply a reduced punishment. It was a final opportunity to prove that he could change course.